If you are in franchising, here are 10 things you need to understand about the California 919 proposed legislation for third-party sellers. 1, it makes improper disclosure illegal and proper disclosure nearly impossible. There is a $50 per amendment change required, and they make the changes in service and changes in compensation material changes. Now, these changes happen daily, and as written, they would require a heavy financial and administrative burden for all who apply. Now, this opens the door to encourage frivolous lawsuits. The definition of material change needs to change. 2, they use undefined terms. The act is full of undefined terms. Things like indirectly involved, offer or sale, attempting to effect a sale, other forms of consideration, is promised. These undefined terms create a catch-all where unsuspecting parties who support the vetting process of a franchise now become third-party sellers who, if they don't disclose under these strict new requirements, they violate the law. Now, think of a person who introduces 2 people on a blind date. Now, the date, it goes well, and they date for a while and eventually decide to get married. Now, they take marriage counseling, they plan a wedding, they even get an officiant, and they get married. They have a family, and unfortunately, they get divorced. The act makes the person who introduced them, the officiant, the wedding planner, and even the wedding singer liable in the divorce settlement. 3, the act fails to distinguish between a franchise broker and an FSO or franchise sales organization. These are 2 industries that conduct different and essentially opposite functions in the franchise sales process. To give an example of a parallel situation, imagine an act regulating a stockbroker who makes a transaction and makes transactions on behalf of the investor. This act makes the referral to the stockbroker and the referral to the referral of the stockbroker and the attorneys and accountants and lead generation sites all fit under the same definition and requiring the same consequences and registration requirements. 4, it forces misrepresentations. The act misrepresents the parties stated and their functions. It then requires the parties to deliver these misrepresentations in writing to potential franchisees. 5, there's a misunderstanding of the broker's tasks and compensation in the act. A franchise broker collects information from potential franchisees about what they're looking to accomplish with this business. They then research all of these franchises that match what that potential franchisee is looking for. They go through territory checks in a process which can be sometimes challenging to find the available and appropriate territories for the person. They then present the potential franchise options. The potential franchisee picks the ones they want to begin the research process on. Then they engage in a slow, methodical, months-long due diligence process with attorneys, accountants, funding experts, real estate experts, and even franchisee validations. The potential franchisee and the franchise they selected then determine the opportunity that those 2 would like to engage in together. Then they tell the franchise broker. The franchise broker has little to no control over that process of selection and approval of the 2 parties, the franchise and the franchisee, into an engagement. The myth that franchise brokers only show brands with high commissions is untrue. And in most cases, the brokers don't even know the referral fee until the transaction has completed. Also, this act assumes that higher commissions are worse brands. What we have seen is the opposite is true. Brands who pay higher commissions tend to be the ones with the larger infrastructure and who are more serious about growing their brands in the right way with the qualified people the franchise broker brings them. 6, the act has a guilty until proven innocent approach. The act does not associate bad acts with the consequences. It makes non-disclosure the bad act. So let's put this in perspective. There is no cost to the potential franchisee for using a franchise broker. There's no contract between the broker and the potential franchisee. The franchise broker has no authority or any decision-making in the process. They're not allowed to grant or offer any sale. And yet, they can be tagged as fully responsible along with everyone else involved for the liability all the way to rescission, which means the entire investment, not what the franchise broker earned or benefits from, but the entire franchise investment. There's also no requirement for burden of proof or cause of damages from that franchisee. 7, because of the undefined catch-all terms in the Act, an accountant or marketing company in California could be sued for non-registration as a third-party seller, and a transaction does not even have to occur. This is worse than a personal injury situation because, at least in personal injury, the accident has to happen. With this, anyone can be sued for non-disclosure. Contingency lawyers will base suits on technicalities and admin issues, not wrongdoing. And anyone touching that pre-sale process can be drawn into the suit for non-registration. 8, the Act asks for inappropriate business details. The Act requires full disclosure of all past franchisees' personal contact information, as well as the exact calculation and amounts of every way a franchise broker makes money. So my question is, does your attorney provide you with a full client list, calculations, and payments of everyone who used their services before you hire them? How about your doctor, your realtor, your lender? No one does this because it makes no sense. Why are franchise brokers required to do this? They are not a franchise. They are not making a potential franchisee sign a 10-year contract to work with them for that full length of time. There is no commitment from the potential franchisee at all. The punishment does not match the crime. 9, there are privacy issues with the Act. The franchise broker does not make a sale, but the Act is asking for all their past sales. So it's a moot point. They're asking for information the franchise broker has no authority to provide. That potential franchisee didn't pay them, didn't sign anything with them, nothing. Franchise brokers are being asked to violate privacy laws on things they didn't sell and that are already being provided by the franchise in the disclosure document for that brand. I want you to think of it this way. My first real job was at Chick-fil-A as a food sampler. I stood outside of the store, and as people walked by, I would give them samples of chicken to see if they liked it enough to come in and buy a meal at Chick-fil-A. Luckily, most of them did. Now, using that same scenario, imagine I'm standing outside of the front door of a retail shop. I don't own the shop, I'm not employed by the shop, and I can't sell you anything inside of the store. But I know that there are valuable items inside, and so I ask the passersby to go ahead and go on in. But before they go in, I have to give them this list of everyone who has ever bought something from this store in the last year. I'm also gonna give their personal contact information and what they bought. Now, if you are that person who knows that if you go in that store, everything you buy from that retailer and your personal contact information is now gonna be given out to every visitor of the store, would you shop there? Would you go in knowing that your information was going to be given out to thousands of strangers? 10, our brokers go through a custom education experience with each potential franchisee and every franchise they are interested in. Every new potential franchisee has different needs. When brokers excel in this process, the potential franchisee also excels in this process of self-discovery, and the Act restricts the ability of good brokers to provide custom support without severe and aggressive consequences for that improper disclosure loophole that we addressed before. California 919 is putting franchising in a bind. It is just not ready for prime time, so speak up now before it's signed.